The videotapes really cut both ways. You know, we've gotten videotapes that have just totally discredited police officers, totally discredited the witnesses against our client. And sometimes the videotapes are black or white. You know, sometimes it helps, sometimes it doesn't. And when it doesn't, then at that time you got to try and look for the best alternative resolution for the client. It may not be going to trial if your client is over there, shooting somebody and he's running away, but then you may have other justifications. This is not murder because of this reason, or if you can argue from some reason, self-defense. I mean, it's hard when somebody's running away, but you just don't know. Somebody else could be shooting at the client. So the videotapes can paint a real good picture, but they can also help so much, and a lot of body cam videos have been very helpful for us and have led to a lot of cases being dropped. So please say one thing and the videos completely opposite.
Hey, everybody. Welcome back to another episode of the Only Lawsuits podcast. Today, we have an incredible guest, somebody that has been on the podcast before, one of the best criminal defense attorneys in the game, Mr. Rajan Joshi.
Thank you guys for having me. Yeah. It's nice to be back.
Yeah, welcome back, man. Welcome back.
He's also one of the fittest criminal
one of the fittest criminal attorneys in the game.
Isn't your tagline fit for your defense?
It is. But now I'm looking at him. I'm like, whoa.
Listen, Rajan, don't let the arms fool you. I got to bring this up because I always have to. Josh looks really fit, but ask him who saved his life.
This guy saved my life in Bon Air when my back gave out diving.
You need to do some back workouts, not some fucking arm workouts, dude.
Yeah, it was that back injury was terrible. It's for moving the safe.
Oh man, but yeah, Rajan, I'm so glad you can come back.
Thank you for having me.
Obviously, our new setup, our new office. Hopefully, we'll have you on a lot more often because me, Josh, and Farah, we talk about criminal cases and we don't know shit about criminal cases. But that's why we like talking to someone that knows criminal cases, right? And there's, kind of what we like about Only Lawsuits is we talk about. Try not to get too in the weeds to make it, a boring conversation that no one wants to listen to. But this is an informative podcast, right? Like we do talk about serious things, and criminal cases are some of the most serious things that happen in a person's life. Two big cases that pop out. There's a lot of big ones that we can talk about, but two of the ones that I want to start off with are obviously the David case. And then there's also the Charlie Kirk case, right? Two very serious cases right now. And the facts of these cases are crazy, right? So the David case obviously involves a celebrity that, evidently or allegedly killed a young girl. And I believe he's being charged with like murder, and also I think it's something like in California, they said because there was a motivation for money, he was trying to protect his fame. And then obviously the Charlie Kirk killing is where a celebrity got killed by someone, right? Very different things. And I kind of wanted to get into those. You handle criminal cases in Orlando, or throughout Florida.
Yeah.
How do you, so when you get a serious criminal case, like a murder case, how do you personally look at the facts of those cases, and what is your mindset that you go through in creating a defense for those clients?
Well, the first thing I need to do is go through the discovery, look through everything, the police investigation, look at what the witnesses are going to say, kind of see the picture that the state is going to paint. And then, we got to go in there and tear it up. Look at the witnesses, see what the witnesses' motivation is, see their credibility. Look at the police investigation because, the police can put together a great case, give it to the state, but when it's tested and, it's challenged, that's where the truth comes out. You can make a murder case look so nice on your reports with all your facts and all that stuff. But when you get the witnesses being challenged by a defense attorney, when you get the evidence and you have that detective over there explaining why in a club where a shooting happened, there's 30 witnesses, potential witnesses, and they didn't question them. They just let them go. You got to make sure that the police do their investigation, because a lot of times the police have already drawn their conclusion, and what they do is they get the facts to support their conclusion. They're not looking a lot of times for the truth, and that's human nature. You already believe something and you go for it. So our job is to challenge that and protect our client. I mean, whatever it takes, you put a witness in front of me, I am going to grill, destroy, interrogate, go all out to destroy that person's credibility, because they're going up against my client. But then you got to take a look at the case. Some cases you really just, they've got the evidence. Nowadays, there's a lot of videotapes all over the place. So in that situation, you got to take a look at it. Was it, premeditated, or was it self-defense?
Speaking of videotapes, I mean, this just kind of pinged into my head. It's not tied to these cases at all. But have you dealt with any of the flock cameras? Have you seen the stuff that's going on with the flock cameras and surveillance?
I know that they're out there. Fortunately, for me personally, I haven't dealt with them yet.
Yeah, I was going to say, when you hear like you just mentioned the surveillance, right? Like there was a movie Eagle Eye where it talks about like kind of like a police state, right? Where and there's so many movies like Minority Report where they talk about this concept of the government monitoring everything you do.
Eagle Eye's a good poll too.
Yeah. I know that. I did a report on that. But like, how does that impact like your strategy and defense? Like when everyone has a client that tells them stuff in confidentiality, and then, say hypothetically you get a video that says, oh, yeah, clearly he's lying to me. How does that impact the way you view, your defense and so on and so forth?
The videotapes really cut both ways. We've gotten videotapes that have just totally discredited police officers, totally discredited the witnesses against our client. And sometimes the videotapes are black or white. Sometimes it helps, sometimes it doesn't. And when it doesn't, then at that time, you got to try and look for the best alternative resolution for the client. It may not be going to trial if your client is over there, shooting somebody and he's running away, but then you may have other justifications. This is not murder because of this reason, or, if you can argue for some reason, self-defense. I mean, it's hard when somebody's running away, but you just don't know. Somebody else could be shooting at the client. So, the videotapes can paint a real good picture, but they can also help so much, and a lot of body cam videos have been very helpful for us and have led to a lot of cases being dropped. The police say one thing, and the video is completely opposite.
So I have a quick question to add on to what you're saying. So a lot of times with these cases, it's supposed to be innocent before being proven guilty, but in the law or the court of public opinion, it's usually the reverse. It's the public thinks that that person is guilty. And then it's the burden of the defense attorney now to prove that they're innocent. Like, how difficult is it? Because you've handled some very publicly profiled cases. How difficult is it to not only prove the innocence of your client, but also to maybe potentially have a jury that doesn't have a preconceived notion of the case going into it?
The one thing I do is I hit it in jury selection. I really stress that, and one hypothetical we give is that, if you're driving, you see the police pull someone over, your automatic instinct is like, what did that person do wrong? And we have to tell the jury that, in this country, our Constitution requires that they believe the person is innocent through each stage of the trial, unless it is proven they are proven guilty beyond a reasonable doubt, and we get them to commit to that. And we hit it home. You're right. It is hard, and it's instinctively to believe someone did something wrong. They get there, they see the defendant sitting at the counsel table, and automatically hear the charge. And you look at the jurors' faces like, whoa, oh my God, sex battery and stuff on a minor. And we have got to go over there and really challenge them and stuff. And it's hard. It really is. I mean, it's supposed to be innocent until proven guilty. But as long as we educate the jury at the first stage of trial, first time we meet them, Then we go through as the case is going on, and in closing argument, we have got to hit that and read them the instruction that the judge gives, and have them commit to that and stuff, and keep pointing the finger at whose burden it is. It's their burden. We don't have to prove anything, but we have proven, and this is why.
So one thing that, specifically for the Tyler Robinson and the David case, there was recently some preliminary hearings, and we got a lot of people specifically with like the Robinson case, like me personally, Josh, hitting on the public perception of stuff. As an attorney, I judge things a little bit differently. I'm a civil lawyer, but when in the Tyler Robinson case for Charlie Kirk, this kid or guy, told his lover that he did it. He also told his family he did it. He turned himself in for the crime. And then obviously, he pled not guilty, and they're putting on his defense. They put on some of the evidence to show, hey, this is what we've got. A lot of people didn't like the fact that I was saying, he's got an uphill battle in his defense, right? For the David case, so there's GPS data from the girl's phone. There's Uber data that shows he ordered the Uber. And then afterward, he used an alias Amazon account to like buy a blow up pool, a chainsaw, and, basically a kill kit after, So it's like this all came out in the preliminary hearing, right? And when it comes to evidence and you seeing these sorts of things in those cases, like what are some of your thoughts, in that situation, like for the David case, for instance?
Well, in a high-profile case, the defense is usually going up against a real challenge because, I've dealt with some very high-profile cases, and no matter what you put forward, if the media has a certain agenda, they're going to keep playing it. I had a really high-profile case where, they would present something, and I would present something explaining it, and they wouldn't air it. So, what happens is it taints the jury pool. In these cases, they're very high profile. They are being played over and over on the news. Potential jurors are watching it. People have already formed public opinion. So it's going to be very difficult in these cases to find an unbiased juror. And sometimes, it takes a long, thorough jury selection to find it. And then at that point, if you're in trial, you've got to almost ask that the jury be sequestered, like when O.J. Simpson was being tried. Those poor jurors had to be sequestered in that situation because it's all over the news, everything that's being played. And the challenge is that some of this stuff that is in the preliminary may not come out at trial. It may not be admissible at trial, or there may be pretrial motions that keep some of it out. But people have already heard it. They've read about it. So you kind of need to find jurors who live under a rock, who don't, and it is hard, but they're out there. Yeah. And then after that, if these cases do go to trial, a defense may ask that the jury be sequestered and not be able to hear. But now with social media, you can't take away their phones. You can just go on there and find out anything. So it's harder as more technology comes in. It's harder to get a fair trial in these high profile cases.
Yeah, and I know it's really hard with that specifically, but I also wanted to ask you, your thoughts on how do you walk back if it is allowed or admitted into evidence, either an inference of someone's guilt, like, the Tyler Robinson case where they're saying prior to he had admitted it, or there's also another really high profile case in the news right now, Brian Kohlberger with the Idaho State murders, where he's trying to recant his admission of guilt. How do you deal with that?
Well, what you do, it depends on, anytime there's a statement, anytime your client makes a statement, first thing you want to do is attack that statement, attack the credibility of the statement. If it's given to the police, can get suppressed. If it's given to a friend, then if it's not recorded, if it's not, and you want to challenge the veracity, whether the statement ever happened, whether that person has a motive and all that. So, you still have to go out there, no matter what they present, whatever they present, a good criminal defense attorney is going to keep attacking. And that's what you do. And you have to argue it to the jury. You have to let them know that just because this person's saying that your client said that doesn't mean it's true. Has the state proven it? Is this person, and then what you do is they will make a statement to the police that, oh, this person said this. And then if they don't articulated exactly on trial, you bring out that statement, you bring out the discrepancies,
Mm.
you hit them with the inconsistencies, you almost torture the person who's getting up on the stand, who's testifying against your client. That's the way you have to do it. I mean, you just got to fight.
See, that's interesting because, like one thing that we look at, the stakes in civil cases is always monetary. Criminal cases is a person's freedom. The mindset that you just kind of showed us is totally different, because when I look at something from a civil perspective, if someone says something, we're allowed to question actual defendants in civil cases.
Mhm.
Obviously, as Dr. Fauci most recently put out there, there's Fifth Amendment protections out there for defendants where the state does not have the opportunity to question them, right? So like for me, when I'm doing an accident case or something, I was in a deposition right before this, right? And when I'm questioning someone and they say something, literally I check that box and I prepare a motion for summary judgment and I know I'm going to win, right? But that's not a luxury the state has with criminal cases. So it's interesting to see that perspective of how you just, you really hinge on the credibility, because credibility just come into play with us as civil, but not as much as the words themselves from the defendant. Whereas, when you have a defendant that is your client that says words without an attorney, like it really does, the way you attack it's interesting. So I've never thought about it in that perspective.
Mhm.
And civil law, we also have a lower burden, right?
Yeah.
So that gives me an idea about why in criminal law there's a little bit more leniency about how much they can attack. Because in our situations, if we have someone up on the stand, they're gonna be like, all right, you need to chill out, right? But they have more, because it's such a high bar and because there's so much more at stake, they have more leniency when it comes to questioning people too.
Well, yeah, and like when we evaluate things, we obviously want to be careful with, like you don't want to attack. I hate to sound sexist, but you don't want a male attacking a female witness.
Mhm.
You don't want a female. Sometimes you don't want a female getting too aggressive
Well,
with.
that's all strategy, right?
So
Yes.
it's like there's so many. You wonder why, we have Farah, because sometimes we need to.
We have to play
need-
good cop, bad cop,
Yeah.
especially in family law when they're depending on whether we're representing the husband or the wife, right?
Yeah. So, but to move into some other new cases, and obviously some things that are kind of going on. There's a case that Farah has a lot more knowledge of than me, but it's the Lindsay Clancy case.
Yeah,
This
so-
is an interesting one.
Yeah. So the Lindsay Clancy case, she's a mother, or was a mother of 3, and she's on trial currently for having, all 3 of her children. She allegedly murdered all 3 of her children with with some type of exercise band or something. And so that's in the news right now. She also is trying to plead an insanity defense. She is claiming that she had postpartum psychosis at the time, but obviously there's, things going either way. I don't know if you saw, just like you're saying, how they need to attack their credibility. There was a lot of attack on her psychiatrist, specifically because she's claiming the defense. So I don't know if you want to speak a little bit to that.
Yeah, and my understanding of the case is that she was being treated, and they are attacking her. The physicians who were treating her,
Yeah.
and the medications she was on. And what's interesting in this situation is this is Massachusetts, and the insanity law over there is a lot different than it is in Florida, in that the state has a burden of proving their case and disproving the insanity beyond a reasonable doubt. In Florida, insanity is the hardest thing to prove for a defense. They have a very high burden. It's clear and convincing evidence. And in these type of cases, it's almost a battle of the experts. When I'm dealing with these type of cases, it is whose expert is going to testify, more adequately and be more articulate as to, whether the person was insane or not at the time. And, over here they have her doctors to attack, which gives the defense a, added advantage, because usually we don't have that. We have psychiatrists who see the person after the fact. And the fact that she was under the care of these doctors and they were prescribing medications and she was, seeking help, does give some credence to her defense. But then they're going to have her continuously evaluated, and the state's experts are going to make their evaluations. And, it'll be, right now it's over in trial. So it just depends on whichever one the juror is going to believe,
Yeah.
the state's experts or the defense's.
And it's really interesting how they're attacking the doctor as well, because and I know a lot of my doctor friends have been really afraid about this because, first of all, medical providers hate being subpoenaed for trial for any reason. I've had this as an issue many times already, so I know this, but this is particularly why, because they don't want to be attacked, and it's never going to be the same. But there's also issues with her medical recording because they were asking her questions about certain notes that she took, whether she said not or was, I think specifically to stressed speech or something like that, as well as the medication that was prescribed. Now, I have a lot of family members and people in medicine, so I understand how the medications work and whether or not I know, she was prescribed Zoloft, right? So they were saying one of the symptoms she was dealing with was insomnia, which could have led to this aggravating a postpartum psychosis. And they were saying, well, why would you prescribe her that knowing that it causes insomnia, or that can be a side effect of insomnia too? So it's just one of those interesting things. Whereas someone who, it shows the jury, it creates that little wedge of doubt, right? That maybe this person wasn't doing exactly what was right for the patient, when we know that side effect Tylenol has a long list of side effects, all of these things. So you can't realistically say, oh, well, why did you prescribe that if you knew that insomnia was, a side effect? But it's a great example of how poking holes in like that expert can either aid or, help the defense.
Well, I feel like, especially with the complexity of like a defense for insanity, like you were saying, the different burdens based on where the location is, and then obviously like the complex understanding of side effects. You know what I'm saying? Like while you were saying some of that shit, I was like, what the fuck is going on? But that, I think that's like, how do you deal with that, Rajan? Because you have to basically teach the jury that you're looking for such a, your jury pool is so limited, because not only do you have something that's being publicized out there, you need to find someone that lives under a rock that can also understand complex, medical diagnosis.
Well, no, they don't need to
and treatment and stuff like
understand
that.
it. You need to show them what they need to understand, right? Which I think is really cool about, something that they do. So that's why I was saying that even though that's a side effect, they're trying to show that she shouldn't have prescribed it because it causes insomnia. But Zoloft is like the number one antidepressant across the board to prescribe for most things in psychiatry. So if someone doesn't know that, what they're going to see is she prescribed something that causes insomnia, which would cause the postpartum psychosis. So that's what the defense is building up.
So normally when you have like experts and you have a complex case, you want to have the experts, kind of dumb it down. If you have an expert out there talking, over the juror's head, they're gonna tune it out.
Yeah.
And what a lot of times what you want to do is you want to get the expert to say certain things that will checklist it, and then argue it in the closing argument. And both sides want to do that. They want to be able to break it down, have their closing ready, and then get what they need from the expert to explain it to the jury. Because a lot of times, going into a closing argument, this in civil, the jurors haven't made up their mind yet. Maybe they have, but you can sway them in closing. Closing, I think, is the key. That is the crux of a case, a trial, is how well you close. And I take a lot of pride in my closing, my preparation, and how I can talk to a jury and break down the complex issues to a very simple form so that they can understand and they can be like, oh, that's what that person was saying for like the last 3 hours while I was sleeping and stuff. And then the other side, is going to come out there and they're going to try and rebut it and stuff. And it's just who can make that lasting impact on the jury.
Well, one thing that I wanted to ask is, especially with like these insanity cases and the one that you brought up, there are actually two others that are going around the country, one in Seattle and the other in California, where I think the one in Seattle, if I'm not mistaken, it was a guy who was given the not guilty verdict for murdering a pregnant woman. And he pleaded insanity. And an Asian man who walked into a gym not knowing the individual inside the gym and shot the person dead. And he was
Should be
also
punished by death.
yeah. Well, yeah, but the jury found him not guilty by a plea of insanity. So, one question to all the question I have for all of you guys is like how difficult is it on both sides where this person is proven not guilty by insanity and maybe they have to deal with the repercussions afterwards, but also finding justice for the family too, right? Because the family at the end of the day is the one that's not getting any justice because of this plea.
Have you
Well-
ever argued in an insanity plea?
Yeah, well, I've argued a lot of insanity
Yeah.
cases and stuff like that. And the one thing is that with insanity, you are saying that the client committed the crime. They have done it, but this is why they shouldn't be held responsible. They did all the things that, they're saying, the killing and all that stuff, but they mentally did not have the capacity to intentionally commit the crime. In Florida, you don't know because you have a mental defect. You don't know the difference between right or wrong. That's the insanity defense over here. And, that's kind of where it is. I mean, some insanities are, even lower, diminished capacity. Florida holds it to a high standard. But yeah, it is something, that if the person is found insane, then they go into an institution until the insanity is restored. And then, there is no prison. There is no, punishment, criminal punishment to them. So yeah, the families are stuck with that. And it's a defense. It's kind of like when somebody's found not guilty, even though the person knew they did it or there's evidence and stuff like that. Maybe some of the evidence got suppressed and, it is sometimes, unfortunate for the families and stuff. And I was joking about the death penalty. You shoot somebody in the gym, that hits me home. So that's why I said that.
The way I look at it is, obviously, as an ambulance chaser, my goal is to
Oh my God, I
find-
can't believe you just admitted that.
Listen, that's what they call us. I own up to it. But realistically, from a personal injury and civil perspective, it is hard to see someone essentially admit to a crime and not be penalized, right? But you have to look at it from a different perspective, right? Who was responsible for that person getting into that situation, right? And I think that draws to a larger question of, how do we hold other people liable for the actions of someone else, right? For instance, if someone, gets found not guilty or the insanity defense works, right? Well, what caused them to get to that position? Is it the educational system? Is there some sort of, external factor that we can impose liability on civilly to help correct that long term? Because, although personal injury lawyers, you see our billboards everywhere, you see all this crap, we only talk about money. The one thing I will say is, guess what changes things? When people have to pay money, right? Yeah. Ford got sued with the Firestone tires when they were blowing up. And guess what? I guarantee you now, you haven't heard of a tire blowing up from any manufacturer, right? And killing people. So civil lawyers work for imposing financial burdens on people to make changes. Now, the biggest thing is, especially that I can foresee with insanity pleas and certain things, is there's going to be a lot of governmental influences like, community exposure, school exposure, like things that happened in school. A lot of school shootings happen because of bullying, right? But can you sue the government for that and hold them civilly accountable? No, there's a lot of like protections that protect the government, sovereign immunity, stuff like that. So, these are things that we, from a civil perspective, I look at, because obviously when he does his job and gets someone a just decision of, guilt by insanity or whatever it is, that is the right decision. But who and how do we hold someone accountable to get justice for the family is the next question we need to have as a society and fix, in my opinion.
I always find it interesting, though, too, because a lot of times with these criminal cases, what's conveyed by the media is like a home run. right? So like by the standards of what you see on the news and all of like these influencers and talk show hosts talking about a specific case, you think that, man, like this person is going to get an immense amount of time behind bars. And then when the case result ends up happening, they end up serving little to no time or getting off like scot-free. So I think like it is kind of fascinating seeing what's perceived by the general public, by the media, and what's actually happening in the courtroom.
That's so true. I mean, you look at Casey Anthony, you look at George Zimmerman, you look at O.J. Simpson. You know, everybody thought they were guilty. They thought, oh, it's hands down going to be a guilty, and you know, they walked. And it's almost like the media has built it up so much, and it's almost a letdown to all the people. You know, I mean, people are found not guilty regularly. You know, in most more serious cases, more heinous cases and stuff, nobody hears about it. You know, but when the media picks certain cases for certain reasons, or it's a celebrity like O.J. Simpson, then people get so fascinated.
People get invested.
They get invested.
Listen, there's Netflix deals on the table, baby.
Yeah.
That's so true.
Yeah. To change the tone a little bit and get to stuff that's a little bit more centralized to Florida, you know, there's not a lot of new laws that have come out, right? Two that come to mind are obviously the super speeder law that just came out, I think last year. And then obviously there's some changes to the DUI law that went into effect, I think recently as well. You know, so one of the things that I wanted you to talk about is obviously this is just Florida stuff, and you're a Florida attorney. With the super speeder law in particular, talk to me about that. How do you approach those? Because it seems like my understanding in law school is no matter what, if they wanted to take you to jail, they could have, right? Like based off my criminal procedure remembrance, but you know, I didn't do well in that class anyway. That's why I'm a civil lawyer. But what do you think about the super speeder law, and how have you seen it kind of play out?
I think the law is ridiculous, to be honest with you. I mean, yeah, it's just, and the way it's being played out, in my opinion, is horrendous. You know, people are being taken to jail instead of given a notice to appear. The state attorney in the Ninth Judicial Circuit, who I've always gotten along with and respect, I went to law school with, is being very tough on these crimes. You know, very tough. I mean, first off, this wasn't a crime a year ago. You know, and secondly, a lot of times people don't have the intention to go past the speed limit. You know, I mean, sometimes people may not be looking at the speedometer and stuff, but you go over. I have somebody recently who got arrested for going 2 miles over, you know, the
30 mile an hour threshold.
No, it's either 50 or it's if you go 50 miles over the speed limit, or if it's 100. She went 102 and got arrested. And you know, the state attorney's office is taking a very aggressive stance. So I thought these cases, when it first came out, I was like, oh, they're just gonna knock it down to civil or something like that. But they're taking a very aggressive stance. So it makes us take a more aggressive stand. And you know, we have to challenge the you know, the speedometer or the method of clocking the speed. And you know, it's going to cause a lot more backlog in the court system over something that should be in traffic court, not criminal court. So I've seen this. I'm not a fan of it, and I have vowed to be very aggressive on these cases in particular. I mean, I drive some fast cars. I am a member of
Yes, he does.
I'm a member of a car club, and a lot of my friends
clientele base.
I know, right? That's the ring right there.
It is, and so you know, I don't speed, but you know, that's one law that I'm looking at, and I'm looking at that speedometer very closely as I'm driving.
Listen, a lot of people probably don't know this, but public record, you can go pull up my name, Michael Singh in Orange County, and you know, I had to disclose I had a lengthy traffic record when I was younger. I'm not proud of it. But I had a sports car when I was younger, and you know, I made stupid decisions.
You drove fast?
No. Used to. Allegedly, I drove fast. But look, you know, I did beat a street racing ticket on my own without a lawyer.
Yeah. Well, I mean, you got the lawyers right there.
He pulled me over in a parking lot, and I was like, "Where was I racing, bitch?" I was pissed. But with that being said, it's like, I do think the super speeder law is a bit crazy, and like, listen, there are legit. The one thing I do foresee being an issue is, like, it is a very harsh penalty, right? Because what used to be a civil infraction, or that would kick down to civil, you now have to hire a criminal defense attorney because the repercussions are very high. So what's your advice to people? And if you get pulled over in a situation like that, how do you deal with being accused of, this super speeder issue?
The one thing is, you don't want to make any statements. Anytime you're pulled over and you can be accused of a crime, just don't say anything. The cop, if he believes you're guilty, he's going to arrest the person. And the more you say, well, I'm sorry, I went over, then that's an admission. Or you say something that commits you, because with body cam videos, you almost can't backtrack it. And, you don't want to say anything that can incriminate you, because then we can go back and attack it at a later time. So regardless of whatever crime it is, you're pulled over, you do not make any statements. You just ask to speak to a lawyer. The other law is what you were saying.
The DUI law. So I was just going to get into that. Yeah. Now, with that same logic, obviously Florida one-upped you and said, okay, you don't want to take a breathalyzer? They passed a DUI law that basically says, okay, if you deny taking a breathalyzer, you're hit with what? It's a misdemeanor. Right?
Yeah, it's a first-degree misdemeanor.
I thought it was usually just automatic suspension of your license.
It is. Yeah. It is automatic suspension. You could get a hardship on it, but it wasn't a crime unless it was the second time you did it.
Yes.
So now it's a misdemeanor, and so someone can have a case where they can beat the DUI, but now they're looking at getting this refusal thing, and so the prosecutor will get their pound of flesh. Because I used to speak a lot on, when I speak about DUIs, I would recommend, I wouldn't say don't blow, but I would say if I was in that situation, I wouldn't blow. But if somebody's there and they almost like, damned if they do, damned if they don't, because then they have the breathalyzer result, which can hurt them in a DUI, which carries mandatory sanctions, or they refuse and they get this refusal, which, but if they beat the DUI, it's hard to advise on that one, which one to do, because you can't advise somebody to commit a crime. So I can't advise somebody don't blow, because
that's interesting. I never thought about that, because that does change the way you have to give advice, because technically, if they don't blow, they commit a crime. I didn't think about that. Holy shit.
That's crazy.
Yeah.
But you could be like Tony Romo. You see the DUI video from Tony Romo?
No.
Dude, Tony Romo, I don't know if it was AI, but it looked like, Tony Romo played for the Cowboys. Cowboys, Tremont likes the Cowboys.
He's a lifelong Cowboys fan.
But basically, they made some edits to, I don't know if it was AI, but they made him look like he was doing like training drills while he was doing the field sobriety tests. And they were like, they did the what is it called? The stimulus test with the eye. And so he's like, they do the stimulus test on the video, and he goes, did I pass that one? And she's like, turn around. He's like, oh, guess not. So this is all on body cam, but I thought it was just hilarious. But
I would still advise somebody, don't do those field sobriety exercises. I will say that it's not a crime not to do it. Do not do it.
Well, we've done a video in the past, a couple of years ago, where people who were like, we did half people actually get drunk. We were all in a safe space, and then half of our staff was sober. And even while we were sober, weren't able to pass.
Yeah.
So.
Well, and another one of my buddies, he told me the same thing. He's like, when we do these field sobriety tests, you're almost guaranteed to fail. You know, like. And I've seen, like, I look at a lot of boating content. There was a case where, at FWC, they pulled over someone and he was perfectly sober, and they still took him to jail because they're like asking him to do like tests on a moving vessel. And I'm like, dude, you can't. I'm like,
I've seen some of those videos too. I've seen some of the sobriety test videos, and at times the officer is trying to set somebody up to fail. I'm not saying that it happens every time, but yeah, I mean, I agree.
All they do is they count all the things you do wrong. They can ask you to do 100 things and you do 5 wrong. They'll be like, you did 5 wrong, and it's all because of impairment, based on my training experience. I used to prosecute DUIs, and I used to use the field sobriety exercise as, the highlight of my case. Now, I argue to the jury, this is more indicative of how a person would do in the circus than, you have like that elephant standing on one leg or the tightrope person. I was like, it has nothing to do with how you're going to drive and stuff. And some of the jurors get a kick out of it. Or if I get an officer on the stand, I was like, you didn't walk up heel to toe like this. So.
But look, Rajan, it is awesome having you back on. You always give a great conversation when it comes to, your perspective. I mean, they call it the practice of law because I learn something new every day. Yeah. So, and you definitely give us a lot of insight. We appreciate your time.
Thank you. I appreciate being here.
We definitely appreciate you, man. And look, to everybody tuning in, thank you so much. If you guys like what you see, please subscribe. And if you guys have any suggestions for any other guest or, any subjects that you'd like for us to discuss, leave them in the comments below. And until next time.
If you get arrested in Florida, just call Rajan.
Yeah, just call Rajan.
You call us, we're just going to send you
the best criminal defense attorney in Florida, folks. All right. Bye.